Welcome to this edition of Legal Insights. I'm attorney Alan Segal, and today we're going to talk about wills in Massachusetts. And the process of preparing a modest estate plan involves a simple will, a healthcare proxy, a durable power of attorney, and a living will. Now, essentially, in order to prepare a simple will, we will need to know, obviously, the correct spelling of your name, how many children you have, if any, whether or not you are married, and a brief description of the type of assets that you own, because a will transfers your assets at death, not prior to death, but at death. If you're going to transfer assets prior to death, you can use a trust or just an outright gift or sale of assets. But in order to transact what's going to happen to your estate when you die, you need to have, at very least, a simple will. Once you've supplied the information to us about your assets and the essential people in your life, we can then prepare the document. And most times, people leave everything to their spouse, and if something happens to the spouse, they leave everything to their children. Sometimes it's not in equal shares, sometimes it is. If you have young children, then you probably want to include a provision in your will for a trust to hold title to any properties that you have and then distribute it to your children at a certain age, or distribute certain parts of the trust property to your children as they're growing up until they reach a certain age. Wills in Massachusetts need to be executed in front of two witnesses, and then there has to be something called a self-proving affidavit that needs to be signed by a notary public and by you, demonstrating that you are of sound mind and that you prepared your will without any undue influence. In addition to a simple will, most people should have what's called a healthcare proxy. And the purpose of the healthcare proxy is to designate someone as your proxy, to be in your stead, so to speak, to make medical decisions in the event you are unable to make medical decisions. You could have been in a car accident. And although you're probably going to be all right, you're in such a state that you can't tell the doctors what to do if they ask questions about important parts of your care. So you need a healthcare proxy to do that. And you nominate someone to be your proxy, whether it be your spouse, a child who is over the age of 18, a close friend, your attorney, somebody to be your healthcare proxy. In addition, you need to have what's called a durable power of attorney. And the purpose of that document is to have someone act on your behalf in the event you're unavailable. It doesn't mean you're in the hospital. You could be away somewhere. You could be in a foreign country. You could be in a situation that you can't fill out for certain papers. So you're nominating someone to be your power of attorney to sign documentation on your behalf. And the final document that you need as part of the package is called the living will. And what that means essentially is that if you are so injured or ill to the extent that there is no hope of reviving you other than to be a, quote, vegetable, then you want someone to make the decision to say, I don't want to be revived. And you've already determined that by preparing the document called the living will. So those are the essential 4 documents you should have for a very simple estate plan in Massachusetts. I'm attorney Alan Segal, and this has been another edition of Segal Legals on Legal Insights, and I look forward to hearing from you.